Randy Orton is going to be making an appearance as a witness in a trial as his tattoo artist is attempting to sue the WWE, Take-Two Interactive Software, 2K Games, 2K Sports, and like a laundry list of other companies. If you recognize the names of these companies, that's because these are the companies that are responsible for the 2K game series. So like NBA 2K, WWE 2K, all those game series that we all love to play, right? They're responsible for all of that. Take-Two Interactive specifically. So the tattoo artist's name is Catherine Alexander, and she filed suit back in 2018. And apparently she's been Randy Orton's tattoo artist for a while now, since like 2003. And she started tattooing him in 2003 and applied several tattoos to Randy Orton between 2003 and 2008, which include like a skull arm design on his arm, a Bible verse design, an upper back tribal design, and some tribal designs on his forearms. Sammy Spina, what's up, my dude? I think this would apply to you. If y'all don't know Sammy Spina, he's an NFL agent. So he represents NFL players who all have a lot of tattoos and are probably featured in video games somewhere at some point. Am I wrong? Let me know, Sammy. Do you have anybody that's been featured in a video game? I'm sure you do. Yeah, peep the ET hanging out in the back. But yeah, Catherine Alexander has been tattooing Randy Orton since 2003. So between 2003 and 2008, she's applied a bunch of different tattoos to him. She filed suit against the WWE and Take-Two Interactive and a bunch of other companies and affiliates back in 2018. So the basis of her lawsuit against them is that they are infringing on her copyright ownership of these tattoo designs. Now, court has already recognized that she does have valid ownership of the copyrights over these tattoo designs, and this is why. In the US, the basic rule of thumb is that the author of an original work is the owner of the copyright in that. So this is how copyright works. As long as it is an original work and is fixed in a tangible medium of expression, it is automatically protected by copyright, right? So in this case, she came up with these original tattoo designs and she fixed them in a tangible medium of expression, being that she tattooed it on Randy Orton's body. So if you take a piece of paper, you draw a picture, you draw something original, you're fixing it to a tangible medium of expression, basically just meaning it can be perceived in some way. You can see it, you can hear it, you can perceive it in some way, right? You can touch it. At that point, that establishes valid ownership over a creative work. This will set precedent in future cases while this case is important for this generation. Yes. That's why I'm talking about it, because this and what's going on with Kat Von D is huge. We got to talk about this stuff because tattoos are huge culture. I love tattoos. I'm gonna get covered at some point, but this is huge because it will change the dynamic between tattoo artists and their customers and the conversations that they have about those designs and who owns the copyright in that design, because you could end up with clients that are currently celebrities, and those tattoos can be redone and featured and show up in magazines and video games and movies and all kinds of stuff. And then you could have clients that are not necessarily celebrities but could somehow become celebrity in some way, right? So again, Catherine Alexander, this is Randy Orton's tattoo artist, filed this claim, this copyright infringement suit against the WWE, Take-Two Interactive, and a bunch of other affiliate companies back in 2018. She has the valid copyright. To bring a copyright infringement suit, you got to prove two things. The first being valid copyright ownership. That's the first thing you got to prove. The second thing you got to prove is that there was a copying of the copyright protected work. I think she's got that here. So back in 2020, Catherine Alexander filed what's called a summary judgment. She filed for a partial summary judgment. So that's basically in a case where you think your case is so strong, you go to the court and you say, hey, I think my case is hella strong. I want you to go ahead and look at the facts in this case, and I want you to go ahead and make a ruling right now. Before we go to trial, before we go in front of a jury, before we do a bench trial, whatever, I want you to go ahead and make a ruling now. That's basically what a summary judgment is, and that's what Catherine Alexander filed. Take-Two Interactive also filed their own summary judgment, saying the same thing, basically asking the court, hey, look at the facts, go ahead and make a ruling. Boom. So the court took it, looked at it. For Catherine Alexander, they looked at it and said, okay, we recognize that you have valid copyright ownership over these tattoo designs. For Take-Two Interactive was trying to claim several different things. First, they were trying to claim fair use. The court kicked that out and said, nope, this is not a question of fair use. This is not fair use. Then they tried to say there was an implied license that they were able to use these tattoo designs or recreate them digitally. And the court kicked that and said no. Somebody said, Mr. Cartoon has tattooed so many celebrities, he's going to be owed some big bag. If this swings in a certain way, that could be true. He definitely could find himself in a situation where he could bring suit in a lot of different spaces against a lot of different people. Somebody said, can I ask you a question? Yes, please. People ask me questions on here all the time while I'm talking. So go, please ask a question. So again, Take-Two Interactive tried to say it was an implied license. Court said no. They tried to say it was fair use. The court said no. They tried a couple of different arguments and the court said no. At the end of it, the court basically said, look, we think that Miss Alexander can go forward and sue and make a case for to collect damages for the licensing fees that she could have been paid or should have been paid for the use of those tattoos. So that's where we're at now, is that Randy Orton is going to be getting called as a witness in that trial as Catherine Alexander is trying to file suit against the WWE, Take-Two Interactive, and 2K Games. I think it's also important to recognize that in 2009, she brought up these issues with the WWE. She went to the WWE and said, hey, y'all are infringing on my copyright. The WWE offered her $450 as a fee for the right to use her designs. I think that's absolutely crazy that they thought that $450 was okay, was like an okay number to offer her, especially with a series like a 2K series, which they know is going to make millions and millions of dollars. And they offered this woman $450 as a fee to use her designs. Nice suit, fam. I appreciate it, man. Thanks. Also, she did file for the federal copyrights back in May 15th. It was like May 15th of 2018. She filed for the federal copyrights over the designs. So that's important too. So I think this is an important case to watch, because this is a $450 offer admissible in court. It depends. So in a lot of situations, if an offer is made, there is a clause that is a part of offers that says, hey, this offer cannot be used in court against us, yada yada yada. That happens all the time. I use it as well in interactions, negotiations, because you don't want to those negotiations, if they go south, if they don't work out for either party and you do end up in court in litigation, it could hurt both parties. So sometimes you don't want that kind of stuff in, but if it's public knowledge, then if we know, then somebody knows. Somebody knows. Music royalties are similar, especially if she can prove her designs were important to the character. No, that's not even necessary. Not even necessary that she prove that the designs were important to the character. All she has to do in a copyright infringement suit is prove two things. She's only got to prove that she had valid ownership over the copyright of the designs. And then second, she has to prove that there was a copying of that copyrighted work. That's it. She does not have to prove that. What are possible damages? The possible damages, hard to put a number on it, but the possible damages would be the amount that she could have made as a licensing fee to use those designs in this game. And that licensing fee could look like anything, right? So if you have a piece of work and you want to license it out, you can put that number on it. You can put whatever number you want on it and tell people, hey, this is what it costs to license out my creative work. It's swinging in her favor. I think that it's swinging in her favor. I believe it's swinging in her favor. And if it does, this is a game changer. And I think this changes that interaction between tattoo artists and their customers and the conversations that they have as far as who owns what at the end of this transaction, right? So when you go in and you get a tattoo, you have to sign off on a bunch of things saying like you're 18, you're a valid age to get a tattoo. You're not drunk while you're getting a tattoo. There's like a bunch of stuff that you have to decide when you're getting a tattoo, right? I think there is going to be a clause included in artists' transactions with customers that either says, hey, I retain the rights, the copyrights, the intellectual property rights in this design, or it'll say something like, hey, as a part of purchasing this tattoo from me, that comes with me assigning those intellectual property rights over to you and releasing those rights over to the customer. I think that's just going to change. This is going to change the way that people interact in the tattoo industry. Kevin 606 Smith, what's up, man? A+ lapel pin. Thank you, dude. It's my Charizard. Dude's preaching facts. I try, man. I really try. She has a legitimate argument. WWE has the audacity to lowball and try to get the summary judgment. Yeah, I wouldn't even call 450 a lowball. I would just call that predatory, right? Because like you as the company know the value of this product that you're putting out, that you're going to be putting out, being the WWE 2K game. You know how much those games generate, and you're only offering this artist $450. Predatory. That goes beyond just lowball.